a clause in respect of appointing a guardian for the minor children in that will. So it is only that aspect that the court invalidated. So it is very important. A testator can do it, he can appoint, but it can't be challenged in court. It is subject to challenge of the surviving spouse. If he's able to convince the court that he can handle the affairs of those children, I think the court will be on our side. Thank you.
Thank you. Thank you so much, Justice Kasali, for that insight from your own experience. If you're just joining us, this is the Estate, Trust and Succession webinar organized by ÄLEX. We were just speaking to Honorable Justice Kasali, who is the judge of the Lagos State High Court Probate Division. We also spoke to Ugonna Ogbuagu, who is a senior associate at ÄLEX, practicing in corporate commercial practice area, as well as in the trust and probate practice area. We also have spoken for a while to Vivian Bogo, representing Mrs. Nana Dawodu, who is from ALM Trustees. And in a few moments, we're going to be speaking with Mrs. Omotola Rotimi. But before we get there, we have a few questions that have come in, which we want to take quickly before we proceed with the other things that we want to discuss on this webinar. So Ugonna, there's a question here for you. One of the, Mr. Adeoye wants to know whether the testator must sign the will in the presence of the witnesses together. In other words, can the testator sign before the witnesses at different points in time, or must he sign in the presence of both witnesses?
Yeah, thank you for the question. So from the Wills Law of Lagos State and from various decisions of the courts, the emphasis has been that it must be signed before the witnesses together, right? If the signature, if the testator signed, in the absence of the witnesses, he must then acknowledge the fact that he signed the will when the witnesses are together. So the signing and the acknowledgement must be done when the witnesses are together, right? Of course, we must say that we cannot, on the altar of convenience, sacrifice the validity of the will. So whatever you can, whatever inconvenience you will put yourself through to ensure that whatever document is subsequently lodged at the probate registry or put in a bank vault or anywhere else where you want to keep the will, you must be sure that it's valid so that it's not called into question later. So the simple answer is that, looking at the law, the Wills Law of Lagos State, looking at court decisions, the witnesses must be present together when the testator signs, when the testator acknowledges the signature that he had already made in their absence.
Oh, okay. There's also one question here for Your Lordship. Your Lordship, someone has asked whether what form this nomination takes, the nomination that you mentioned about as another means of devolving property or devolving assets. Someone says, is it drafted like just as you draft a will?
That was why I said it is very similar to a will.
Yes.
It is drafted like that, but it's only fund that can be transferred, not property.
Okay.
It is very, very similar to a will. I think I mentioned it, that is similar to a will.
Yes.
Because it takes effect upon the death of the nominator. It is when the nominator dies that the nominee becomes the owner of the fund. Like if a testator bequests an asset, a building, a motor vehicle to someone, you cannot take possession of it until after death. That is how nominator 2 is, but it's only in respect of funds.
Okay,
thank you.
Thank you very much, Your Lordship. And just flowing on from that, we still have a few questions in the Q&A area, which we're going to take later, but just flowing on from what you've just mentioned, we wanted to find out, Your Lordship, what happens to the estate of a person who is incapacitated and cannot make decisions for themselves? Are such persons then unable to devolve their property? And if not, what happens in that type of scenario?
Like Mr. Ugonna rightly said, you have to be of sound mind before you can write a will. If you are not of sound mind and you write a will, the law will take cognizance of the fact that this person is not of stable mind. And the estate will now go to the administration of estate to salvage those properties from the extended family, from this, disinheriting the family member of this incapacitated person. The law will take its course by knowing that this man, at the time that he made the will, is not of sound mind. So the estate will now be given to the administration, like the AG and PT, they can handle it, and they will now be in a position to divide or administer the estate for the beneficiary. So they will not allow the average to go into salvation or to go into the hands of extended family who may, for one reason or the other, disinherit the immediate family of the testator.
Thank you. Thank you very much. So let's talk briefly about executors. What advice, Your Lordship, do you have for an individual who is looking to name an executor in their will?
Normally, what actually happens is that you cannot make somebody that is not well known to you as an executor of the will. Is either a relation of you, an elderly person that you know your children are really familiar with. So at the end of the day, when the wills are read, it will not be the question of, I don't know this man, how can this stranger come and be administering and be distributing an estate? An executor should be a reputable person, a fit and proper person known by the wives or wife, as the case may be, the children, the relation, somebody that is of good standing, that the testator should appoint as executors, not just anybody. Thank you.
Thank you. Thank you very much. Ugonna, flowing on from this question about executors, if somebody has been named as an executor in a will, is it mandatory for them to accept that appointment?
Okay, can you hear me?
Yes, we can hear you.
Okay. So a named executor is not compelled or mandated to accept or to act in that position. In fact, the civil procedure rules of the Lagos State High Court provides that you can renounce, probate of a will. That's renounce your position as an executor. Some executors, after they've been appointed, they will simply not appear. They will not take steps to apply for grant of probate. They don't show up. They've been asked, to come during citation. They just don't show up. In which case, the administration of estates law of Lagos State provides that that individual will cease to be an executor. But of course, that's not a professional thing. So, if you're unwilling to act as an executor, you can renounce by virtue of the existing laws.
Okay. So basically, where a person is named as an executor, they can basically renounce that position.
They can renounce
so it's not mandatory. It's not something that you must pick up. Okay.
Correct.
So what are the main factors that one needs to consider? So if I have been named as an executor, what do I need to consider when deciding whether or not I should accept that appointment?
Yeah. So you need to consider whether you have capacity and ability to carry out that duty, the duties associated with the position of an executor. If you have some mental illness, right, which you've not disclosed to any other person, would usually be the case. At that point, it may be wise to let the testator know, because usually testators approach maybe their friends or whoever to say, please, I want to name you as or nominate you to be an executor in my will, and things like that. So at that, if you have such condition, it may be wise to let the testator know so that he can look elsewhere, because there are actually provisions in the High Court procedure rules to the effect that if a person is shown to not be of sound mind, probate will not be granted to that individual, right? So that we solve the problem at the beginning and not down the line. The other thing is whether you have the time actually to carry out the duties associated with that position, because just literally you have the interests of these beneficiaries in your palms. You have to give effect to the wishes of the testator. You have to share or distribute the assets in the way that has been stipulated in the will. These are serious issues. They shouldn't be taken lightly. So you have to confirm if you have the time. In fact, what we advise people to do is that when you are approached by somebody, when a testator says to you, oh, listen, I want to name you as an executor in my will, first thing you should do is to ask for information. So what do you think, what would you want me to do after you've gone? What would be the nature of my duties or responsibilities? Some executors are only required to apply for probate and then distribute assets.
Yes.
In that case, you don't need to be hands-on, right? It's something that can be done over a certain period. So, you can just do that and everybody goes their separate ways. It won't be that tedious. But in other cases, an executor is required to do other things. You may be required to manage trust property, right? When the rental, let's say for instance, rental income arising from trust property comes in, you will then share that money, amongst the beneficiaries. And that duty or that responsibility continues to roll over each year. In that case, you need to be able to be present, right? To perform that duty or to carry out that responsibility. In fact, I've seen a will where as part of his responsibilities, the executor was told that every December, he would convene a meeting of all the beneficiaries in the village home or the country home of the testator. They would discuss issues relating to the property, to the deceased estate, and then pray for God's blessings and guidance, for the coming year, right? So for you to be able to do that, clearly you have to be around. If you're somebody who hops from Geneva to Vienna, from Vienna to New York, and things like that, you won't have the time to do something like that. So it may give you the opportunity to politely, decline. So these are some of the things that you need to look at, because the truth is that, performance of your duty as an executor is a serious issue. In fact, there's a penal provision in the High Court Civil Procedure Rules to the effect that if you fail a statutory duty, because executors have the statutory duty of filing annual accounts. So if you fail to do that, you are actually exposed to possible penalties from the court. And those penalties are serious. The rules provides that you'll be liable to pay a penalty of 100,000 naira for each year of default. If you fail to pay that fine of 100,000 naira, they may then seize your property, essentially distress, carry out distress, and then if in seizing your property to pay the fine, it's not enough, you can go to prison for a maximum period of 6 months. So it's actually something serious. If you're not able, by virtue of your circumstances, by virtue of your health, to carry out the responsibilities of an executor, it's best that at the point where you've been approached initially, you make that point so that the testator can look for somebody else, or after the testator may have passed on and maybe your circumstances have changed to the point where you can't carry out those duties, you may decide to renounce, right? Or even maybe apply for probate to be granted to your attorney, to a lawful attorney, if you won't be around. So these are some of the options that are available to persons who have been nominated as executors.
Thank you very much, Ugonna. And this ties in very neatly with the point that Her Lordship made earlier on, which is that when appointing an executor, you need to know who you are appointing as executor. It is best if the person is someone who is known to you in person and in character. And so you know that this is the kind of person that is able to administer your estate, has the time to administer your estate, and will carry out your wishes as set out in your will. That's a very important point. And it's also very important to know that you don't have to accept. If you cannot carry out the obligations that will be required of you, then please decline and renounce that position so that you don't find yourself faced with penalties and issues that you did not anticipate originally. Under the law, I know that corporations can be appointed as executors of an estate. So this leads me to ask a question, Miss Bogu. entities like ALM trustees act as executors and administrators of estates?
Yes.
Okay, so what's the specific procedure that a testator needs to follow then if they want to appoint a corporate body to act as an executor?
So yes, entities like ዄLEX trustees act as executors and administrators of an estate. We are duly licensed by the SEC, that's the Securities and Exchange Commission's regulators, as trustees and corporate investment advisors. So to appoint a corporate body as an executor to your estate, there must be a formal appointment letter duly executed between the clients, that's the testator, and the trustee, in this case, ALM. So the appointment letter should clearly spell out the role of ALM as executor and the professional charges charged for this service. And then the appointments must precede the mention explicitly in the will of the nomination of such corporate entity as executor. So first, there should be a letter stating out that you are appointing this trustee to act as an executor to your estate, and then it must be stated in your will also.
Thank you very much, Ms. Bogo. The other question that I wanted to ask is, are there any specific benefits to appointing a corporate executor as opposed to appointing an individual?
Yes, there are several benefits on why a testator should consider using a corporate entity. A corporate entity, as we know, is a going concern. So you avoid a situation where the individual nominated as executor dies and the estate is unable to find a suitable individual to replace them. This would adversely affect the estate and the beneficiaries. Another reason, because we are registered with SEC, that's trustees are registered with SEC, which supervises and ensures global best practice standards maintained, is also a major advantage. Another advantage is regulatory standards and oversight ensures that corporate entities cannot deviate from the stated instructions that have been given by the testator. Otherwise, they will be liable for professional negligence. And a claim for damages would definitely arise against this corporate entity. More importantly, they could have their license withdrawn by the SEC, that's the Securities and Exchange Commission. These are serious sanctions. Another reason is corporate entities have experience, they have the required skills in their team. So I think these are enough reasons why anyone, a testator in this instance, should consider appointing a corporate executor.
Thank you. Thank you so much, Vivian. So we've spoken quite a lot about the importance of having a will, the importance of planning your estate ahead of time, especially in these uncertain times, the importance of having the appropriate experts guide you through the process. So make sure you have your lawyer on hand, and not just any lawyer, but a lawyer who understands the process that you want to embark on and who knows what you need to have on ground to make sure that your will is valid. We've spoken quite a lot about all of these parts of wills, and I'm sure that the viewers have a few questions that they want to ask. But Mrs. Rotimi, we want to get to you really quickly now. You are the Administrator General, and we know that no matter how much we talk about wills, there are people who are going to die intestate. And of course, where there is no will, this person's family members will definitely apply for grant of letters of administration. So what we want to know now is, under what circumstances that can letters of administration be granted? Hello? Mrs. Rotimi, I don't know if you heard my question. The internet seems to be a bit sketchy. I was just asking under what circumstances a letter of administration can be granted where a person dies intestate without making a will.
Hello, can you hear me at all? I'm losing you. Hello?
Yes, we can hear you.
Yeah, can you repeat the question because it's fluctuating here.
Yes, the internet is a bit sketchy. Okay, so the question was, Under what circumstances are letters of administration granted, you know, where a person dies without making a will? Then what's the procedure? Under what circumstance do you grant a letter of administration?
A letter of administration will be granted where a person did not make a will. The person did not make a will. And in circumstances where, for instance, a person will apply for the LA where, for instance, the court is not satisfied, first of all, with the succession, that is on ground. Then the office of the Administrator General will have to come in and apply for LA in that instance now. And then also where there is, for instance, where there is a reason for maybe suspicion that there might be mismanagement of the assets, or maybe the assets is likely to go into deterioration, probably because the beneficiaries have not come, then the office of the Administrator General and Public Trustees will now have to come in and apply for letters of administration. Also, where the validity of the executor is contested as well. So in such instance, the matter is brought to the office of the Administrator General and Public Trustee, and then we will now have to apply for letters of administration in that area as well. Also, where the person, maybe the beneficiaries are unable to prove their claims as well, or maybe they are not able to get their grants, a grant of probate, probably because of they have not been able to fulfill all the requirements. And then in such circumstances, well, the Administrator General and Public Trustees Office would apply for LA to ensure that for the security of the estate, to ensure that the estate is properly secured pending the time that the beneficiaries would be able to sort out their issues in court. And then also there might be instances as well where for instance, maybe the beneficiaries and the executors are at loggerheads. And there are issues where we have minors. Those minors have to go to school, they have to pay expenses, school fees, buy books, and maintenance allowances for those children, pending the time the issue of the estate will be resolved. In such instance as well, the Administrator General and Public Trustee will be able to apply for letters of administration to manage and to administer the estates.
Thank you. Thank you very much, Mrs. Rotimi. And I think it's very instructive that you've made a particular point, because the Lagos State High Court Civil Procedure Rules actually provides that letters of administration can be granted even where a will exists. So I know that letters of administration are typically referred to as letter of administration with will attached or annexed, where such a scenario exists. And it's instructive that you've made that point, that even where a will exists, there are certain scenarios or certain circumstances where a letter of administration can still be granted. So this takes me to our next question, which is, so who can apply?
Hello?
Who can apply? Hello, Mrs. Rotimi. Hello, can you hear us, ma'am? Hello?
Yes, I cannot. Yes.
Oh, okay, great.
I'm straining to hear. Yes, those who can apply.
Yes, who can apply?
Well, those that can apply, the first person, you see, it's order of priority, really. It's order of priority according to section 49 of the Administrator's Estate Law of Lagos State. It has to be order of priority, and the first person on the list will be the surviving spouse. That is, if they are legally married, the surviving spouse will be the first on the list. of people that can apply for LA. The second set of people will be the children of the deceased. The surviving children of the deceased can also apply for LA. But where perhaps maybe one of the children is deceased, then the children choose of his or her parents, the parents. So either parents of the deceased can also apply. Then the next set of persons that will be able to, that can also apply will be the full blood brothers and sisters of the deceased, of the deceased person would be able to apply. And in the absence of those, half brothers and sisters can also apply. In most cases, in such circumstances, it could be the maternal brothers and sisters, that is, they share the same mother and they probably does not share the same father, would apply. But then where those ones are absent as well, then the half brothers from the father's side can equally apply. Then you can now have aunties and uncles that are related, blood, before that, the grandparents. Immediately after the blood brothers or sisters or half brothers or half brothers and sisters can apply, grandparents, if they survive this disease, can also equally apply if they are still alive. Then the next set of people will probably be the uncles and the aunts of the deceased. The blood aunt and uncle of the deceased can also apply. Then after that, you now have the creditors, where the deceased had probably had taken out loans and other he had taken out, let's say, loans or borrowed money. In the absence of all these other people applying for the LA, the creditors also can equally apply to say, I'm applying for LA so that I can recoup or recover the debt of the deceased person. And then the last people in the CADA is my office. The Administrator General will now be the last person in that CADA that can apply for LA.
Okay. So what are the circumstances in which the Administrator General will be appointed as the administrator of an estate?
Well, one of the circumstances will be where the estate is not represented at all. That is where the next of kin is not known at all, or probably they are outside the country. Then the AG, the court, will appoint the Administrator General as a sole executor to manage the estate. Then also where there had been neglect, like as I said earlier on, and nobody is actually taking care of the estate, and the estate is going into wastage or ruins, then the office of the AG, I'll just abbreviate and say the AG's office, Administrator General's office, would also would come in as the administrator of the state. And then also where there is a pending suit, a substantive suit between the families, between the beneficiaries and the executors in court. And in order not to go to waste, the court can also order that the AG's office to come in and manage and administer the estate pending the outcome of the suit. Then also, where there is persons of unsound mind as well, the Administrator General Public Trustees Office can actually stand in as a guardian to that kind of person. Likewise, a minor as well. And then there are instances where even the executor himself can voluntarily release his power and say, look, I'm tired of managing this estate. Administrator General Public Trustee, take over. Then in such instance, we will also, we can take over the property and administer the property as well. And then finally also, where there is complete uncertainty of who the successors are, that is who the beneficiaries are, who is to succeed the deceased. Then under the section 14 of the Administrator General and Public Trustees Law of Lagos State, section 14 of it, then the office of the the office of the Administrative General can also come in to manage such estates.
Thank you. Thank you. There's a particular scenario that has been at the back of my mind, and I would just like to put that question to you, Mrs. Rotimi. So let's say it's a hypothetical scenario, but let's say a certain man is legally married to a wife and has children, but at the same time cohabits with another woman with whom he also has children and for whom he is financially responsible. And this is a scenario that we sometimes see play out. If this man in question passes on, and at the time of his death, there's his wife and children, and there's his partner who he cohabits with and children, and there's also his parents. Who can successfully apply for the grant of letters of administration?
Hello, can you rephrase? I'm losing you.
Okay.
Hello?
I was saying between where there is a married
can you repeat the question?
Yes, I was just about to repeat it. Where there is a married partner and an unmarried partner, but an unmarried partner for whom the deceased person is financially responsible for, and both of these partners have children for the deceased person. At the time that an application is made, who will successfully apply for the grant of a letter of administration? I don't know if you got the question, Mrs. Rotimi.
Okay, hello?
Yes.
Yes, I think I have an idea of the question because the network is really fading. Yes, it will be the legal wife. Hello?
Yes.
It will be the legal wife as against the mistress or as against the other wife that he cohabits with. It doesn't matter whether for the upkeep of the woman and her children, the legal wife would be the one to apply for LA. But where the legal wife doesn't apply, the children, said earlier, even children of the other wife, because they are his children, they can equally apply for LA.
Okay. So thank you very much for that clarification.
But the other wife, hello?
We can hear you.
The network is bad. Hello?
Yeah, I can tell. I can tell that the connection is not very good. Okay, so I was just going to ask a follow-on question. I was going to say, maintaining that same scenario, between the legally married wife and the parents of the deceased, who can successfully object in this case? Now, who can say, no, we do not want the letters of administration to be granted? Is it the legally married wife, or is it the parents of the deceased?
The legally married wife, certainly, would be the one to object. Yes, but then, she can have the backing of the parents as well.
Sure. Okay.
Hello?
Yes.
The legally married wife, because she has the children. Yes, because she will be acting also on behalf of her children. She will be the one to actually object. And then, of course, she can have the backing of the parents of the deceased as well.
Thank you very much, Mrs. Rotimi, for taking us through administration of estates and in particular letters of administration. We want to talk about private trusts now. So I'm going to come back to you, Ms. Bogo. regarding the concept of private trusts. I know that it's not very common in Nigeria, but I even see that one of the questions here is regarding the concept of private trusts. Can you talk to us a little bit about the different types of trusts and how they can effectively be used in planning an estate?
Okay. So firstly, a private trust is an arrangement where the owner of the asset, known as the settlor, transfers legal ownership or rights to a party known as the trustee to hold in trust for the benefits of a specified beneficiaries. So there are typically three parties to a trust. So we have the settlor, the person creating the trust, the trustee, the person who the assets are transferred to, and then the beneficiaries, the person who at the end of the day will gain from the trust.
Thank you. So how does one set up a private trust?
Okay, so a trust typically, it depends on the individual specific details and what they want. So usually as trustees, we would recommend that you seek professional assistance if you want to set up a trust. It is always important to note that it is actually like a very tedious process and usually typically costs more than other bill drafting. It's more costly than bill drafting. So it is very, very dependent on the peculiarities of each client. To simply answer your question, we would advise that if you have interest in creating a trust, because of how specific your own needs might be, that you reach out with ALM trustees so we can advise and give professional guidance.
Okay. So I have a few questions also that are just specifically related to the COVID-19 pandemic and the restrictions that it has basically imposed on a lot of administrative processes. And I'd like to direct this question to you, Your Lordship, Justice Kasali. Are there measures that have been put in place in the probate division to ensure that the pandemic and everything that's going on right now does not affect the processes that relate to the grant of probate?
Are you asking whether they are? Come again with the question.
No, I'm just asking whether, in light of the pandemic, there are any measures that have been put in place at the probate division just to ensure that, that processes are still going on as normal and that nothing is hindered on account of the ongoing pandemic.
So I know the probate division has gone digital. So you don't have to come to the High Court before you file processes. So you can sit in your chambers and do a lot of things, maybe virtually, at least the payment of money that you need to pay when you apply for letter of administration. And there is something that a lot of people, normally the concept is very wrong. A lot of people believe that you have to register a will at the probate division. You don't have to register a will. It is just deposit a will at the probate section division for safekeeping. No need to register a will. A sealed will that has been drafted properly by a competent lawyer will be taken to the probate division just for deposits and to be sealed by the court. Because of e-filing and there is e-probate, I think the pandemic will not actually affect the probate division of the Lagos High Court. Thank you.
Thank you. Thank you very much for that clarification. Our time is actually very fast spent and we have quite a few questions here. So I'm just going to go straight into the questions so that we can take as much as possible before we have to bring the webinar to an end. Of course, if there are any more questions, I encourage people to send them in. Any questions that are not answered right now will definitely be answered after the webinar, but please send in your questions.
Please, can I just chip in something?
Yes, my lord.
Yes, the witch law of Lagos State has done away with signing at the footnote because Mr. Ogbuagu mentioned that one of the requirements of the will is that you must sign at the footnote of the will. The witch law of Lagos State has actually done away with that. You can sign any part of the will and it will be valid. It doesn't have to be the footnote. So I just want to correct that. Yes.
Yeah, thank you, Your Lordship. Thank you for that very important clarification. Your Lordship, there's a question here that is directed at you. Miss Omude wants to know whether, with regards to joint ownership of property, if you own land or property jointly with your spouse, can you not put your share of that property in your will, or will the whole land revert to your spouse when you pass on?
The spouse, now I want it defined. If it is a man that is writing a will and you have a joint property, husband and wife can make a joint will. But in the event that they are not ready to make a joint will, you cannot impose in your will the property that you own jointly with your wife. That is why I said in the first instance, before the man, if he knows he's going to write a will, he may make a suggestion about selling the property so that the proceeds of his own from the property may be put into the will. But we have instances of husband and wife having a joint will. In that case, you can put in the joint property. Because joint property is like a family property. If it is not partitioned, it is not only your own, it belongs to the two of you.
Okay.
Thank you.
Okay, thank you very much. There's another question here about guardianship. So this person wants to know, if you can appoint another person as a guardian while your spouse is still alive, the guardian that you have appointed, is this guardian just for the purpose of finances for the children, or is it also to physically take care of those children?
It has to be specified in the will, in the clause of the will, that the guardian, the testator is appointing, it is for so purposes. If it is specified and the surviving wife knows that she is in a better position to do all those things listed that the guardian in the will should do, that is why I said it can be challenging. But it depends on what is stated therein. If it's just for their education, the moral aspect, maintenance, the testator has to specify it, and the person that is drafting it must specify what that guardian is supposed to do in respect of the minor children. That is why it is very, very important to get a professional. Anybody can draft a will, but it's always better to get a professional to draft your will so that we know what and what should be put in the will.
Thank you very much. So flowing on from that, there's another question here, and I'll direct it to you, Ugonna. It says, what are your thoughts about leaving the will in the custody of the lawyer or the firm that drafted the will until the demise of the testator?
A lot of people do that. They will even have a copy in their house. But the problem is, if you leave a will with a lawyer or the person that drafts the will, unless you tell one of the beneficiary that my will is in a so person's hand, it will be very difficult for them when you die to know where the will is. Some have saved in their rooms where they keep the will. Maybe they will break open the safe before they can bring out the will. But if you deposit your will in the court, that is the first place that beneficiary relation will look at that. Let us go and check whether our father left a will before he died. Unless you are going to confide in one of them that this is my lawyer, ask anything in respect of my will, and I know a lot of testators won't do that, especially testators with many wives. So it is always better to leave or deposit your will in the probate division. Thank you.
Okay.
Let me also add that, and that's a very good point that my lord just made, because when you go to the registry to retrieve the will, when you go to lodge it, there's a book where you would indicate the date it was lodged,
and it will be sealed.
and all of that. Exactly. So it's on record as to when it was lodged. So it's not a will probably made after the testator died. So that's a good point.
Yeah. So that's a very good point. Thank you very much, Ugonna, for that addition. My lord, this question is also for you. It says, in the case of a deathbed gift, would there be a conflict if that item gifted was already bequeathed in a will? And how will such a conflict be resolved?
A deathbed will cannot be included in a will, because if it is included in a will, it cannot be a deathbed will. Because it's at the contemplation of death that the person will think, okay, if I die, let me give this house to Mr. So, or my son. Mention the name of his son. But after recovering, the gift cannot pass to you. So it can be in the will. It's different. It's totally different from the will.
Yeah, I think this. I think this question relates to a scenario where the gift is already in a will, or somebody has written a will. Say, for instance, a property that's jointly owned. So somebody has written a will and they've gifted that property, and somebody else at the point of dying or on his deathbed then says, "Oh, I'm gifting this same property that's already contained in some will to another person." What would happen in that type of scenario? And I know you've already mentioned, you've already alluded to what would typically happen where it's a jointly owned property.
If it is contested, the will, the will will supersede a deathbed gift. It will supersede. Because the will is the wish of the testator after his death. In deathbed gift, if the man recovers, the gift cannot pass. So definitely the will take priority over a deathbed gift.
Okay.
Can I also add that if the deathbed gift was to supersede the provision in the will, it would amount to essentially a revocation of part of the will.
Yes.
And
that particular part.
Clearly, yes, that particular part. So the section 13 of the wills law clearly states that the only way a will can be revoked, or part of the will can be revoked, is as is provided for in section 11. And if you look at section 11 of the wills law, you will see that it basically contemplates revocation by marriage, under the marriage, by subsequent marriage under the marriage act, revocation by destruction, and revocation by another will or codicil. So it doesn't contemplate the deathbed gift scenario. It doesn't contemplate that.
Okay. Ugonna, there's also another question here for you. And it says, can you appoint both an individual and a corporate executor to jointly execute a will?
Yes, you can.
Okay. So are there any specific benefits to doing that, to having both an individual and a corporate executor?
Yeah, well, Ms. Buwo has already mentioned the benefits of having a corporate executor, which is the fact that, it's a corporate body. So the chances that it will go AWOL as a human being would be greatly reduced. There's also the fact that a corporate body is organized. We've seen instances where natural persons who are executors have failed to carry out their duties as they're supposed to. But people who actually specialize or have expertise in that particular line of business are clearly in a better position to help out. So I suppose those are some of the benefits you would have if you brought a corporate executor into the picture. Unless Ms. Bugo wants to make further additions on that point.
We have.
Yeah.
We can't hear. Sorry.
Okay. I said, I think Mr. Ugonna already said, like, he gave a summary of why you should consider using a corporate body as an executor. So you have the advantage of the fact that they are always there. It's a going concern. They are registered with a regulatory body that sees to their affairs and ensures that they go strictly with the guidelines and all that. So yes, it's advised to use a corporate body.
Okay, thank you. Thank you very much, Ms. Bogo. There's another question here for Mrs. Rotimi and Milord, and Mrs. Rotimi had actually addressed this question already in one of the scenarios that we had put to her. Basically asking whether where a mistress is married to the deceased under customary law, can that mistress insist on being made an administrator to the deceased estate? And Mrs. Rotimi, I know you had answered the question earlier, and you had basically said that as between the mistress and the lawful wife, the person who would be entitled to the grant of letters of administration would be the lawful wife. I don't know if my lord has any more contributions to make on the point.
Yes, just as Mrs. Rotimi rightly said, it is the person that are married under the Act that we have the right. There is nothing anybody can do. Marriage under the Act is so important. I'm not saying that other marriages are not important, but that is what the law recognizes. So I don't think there's any other thing that anybody can do about that. The mistress will have to be the one that will build. Thank you.
Okay. Your Lordship, another question for you here is, when does a joint will come into effect? Is it when both parties die?
When does a
joint will? Yes.
Yes, when both parties die.
When both
that
parties
is when it will, because they have done it together. If at the demise of a testator who is a man, the will cannot pass until after the other spouse, after she's gone. It is after.
Okay, Ugonna, a question here for you. Is it only a man that can appoint for guardianship of his kids? Can't a woman do the same?
Well, I mean, I believe a woman can do the same. I don't see any legal impediment, unless there's something my Lord Kasali can do, which I'm not aware of. I don't know if any.
Yes, let me just chip in.
Yeah.
A lot of women are well-to-do than their spouse. If peradventure the woman dies before the man, and she has left a will that a guardian should be appointed by the executors, she must have known the reason why she doesn't want all her estate to be given to that surviving spouse. Like I told you, this question of the guardian for minors can be contested, can be challenged in courts. So it now depends on the man. The onus will now shift on the man to come to court to give a cogent and convincing reason why that aspect of the will should not be invalidated. Because the woman that wrote the will must have known that maybe the husband is not responsible. After bequeathing everything to him, he will be marrying a lot of wives. He will not take care of the minor children. That is why she decided to appoint a guardian for those minor in the will. It is subject to challenge. And if after challenge, the court feels the woman is right because the guardian cannot even prove that he can take care of those children, maybe with a lot of reasoning, then the court will leave the will as it is. Or if he was able to convince the court, so be it. So a woman can, depending on the type of husband that has been living with.
Okay, thank you. Thank you very much, my lord. There's a question here that's not directed to anyone in particular. And I'd just like to direct it to Ms. Bogu and Ugonna. It says, can a conglomerate chairman establish a trust to ensure that his beneficiaries enjoy ownership of that conglomerate and its proceeds, and also ensure that the conglomerate runs smoothly even after his demise? So
yes. Okay. No, go ahead.
No. I was just trying to explain the question. Basically, if someone owns a group of businesses or a conglomerate, can he establish a trust to make sure that his beneficiaries will get possession of that conglomerate and continue running it after his death?
Yes, he can. So it depends on his wishes and what he actually wants. At the end of the day, he must clearly instruct the trustee to ensure that all of these assets are distributed to his beneficiaries. All of these instructions will actually be in a trust deed that will be duly executed between the settlor and the trustee. So yes, you can actually direct and give instructions that all of these businesses and assets should be directed and distributed to his beneficiaries.
Thank you. Yeah. Thank you very much, Ms. Bogo. Ugonna, do you have any contributions? Are there any obstructions to the devolution of a group of companies?
Yeah, I don't think so. If you look at some of the trust documents that we've worked on, there have been similar structures where ownership essentially has been moved on to the beneficiaries, and they've been able to enjoy the proceeds of that, conglomerate. I'm even trying to remember. I'm trying to remember how the structure for NWLR worked, because when Chief Fawenimi died, he set up something that how the entity that publishes NWLR, to continue to operate right on its own, and then his will was published in the papers. I'm just trying to remember the exact provisions, but he had something similar where NWLR was operated under the legal entity that housed it, and then proceeds going to the relevant family members. So it's something that's very much doable.
Okay, there's another question here for you, and it says, what is the minimum number of executors that can be appointed?
Yeah, the advice usually is that you should have at least 2 executors. The reason is that there's a chance that somebody may be unavailable. It wouldn't then leave it would, at least there will be somebody who can then take on the mantle of managing the assets. In fact, going back to one of the previous questions that was asked as to the benefits of having a person work as a co-executor alongside the corporate trustee, as a natural person who can die, anytime, the corporate trustee is always there. So if one executor is unable to function, you would have somebody who will step in. So advice to people will usually be, please have at least 2 executors. It helps in terms of continuity. It also helps in terms of fairness in dealing with the estates, right? I think even with regards to the issuance of letters of administration, you would find that the probate registry would only issue letters to at least 2 administrators, right? That having 2 people on board will always help ensure that the dealings with the estate are fair and transparent. So we'll always have 2.
Thank you.
I don't know whether this question.
Sorry?
I don't know whether this question will be asked, but it is very important that we mention before we end this webinar in respect of will, that it is always available for testator to amend his will. The fact that you have written one will doesn't mean you should leave it there. If anything changes, maybe you marry another wife or marry more wives or have more children, there is something that we call codicil. Codicil is like an amendment of a will, and you can have 1 or 2. But if it is more than 1, it is always advisable to write another will instead of having a lot of codicil. I just say I should mention it because it is very important.
Thank you.
You can make a will when you are 40 years old. Yes, you can make a will when you are 40 and you may still be alive when you are 90. During that 50 years, you must have acquired a lot of things which you need to put in your will. So you go back, write another will, and the other will that has been written earlier will be revoked so that the codicy and the new will now be your will. It is very important.
Very important. Thank you very much, Your Lordship. There's one further question for you, Your Lordship, and it says, must the deathbed will be in writing?
Deathbed will, it shouldn't be in writing. It cannot be oral. Because it's not a will, but it's something that should be documented. It should be in writing. You cannot, by way of word of mouth, say, I'm doing this for you. It must be something that is in black and white.
Yes. Yes. Okay.
Yeah, I think because you will also remember that, in fact, just contractually, you can't by oral.
Not binding.
The contents of the written contract. How much more a will?
A will or the gift of an estate. Yeah. Obviously, thank you very much, Justice Kasali. Thank you, Ugonna. Mrs. Rotimi, there's one question for you here, and it says, does a letter of administration extend the death benefit of an annuitant to other beneficiaries, or where other beneficiaries have been named by the policyholder. Hello, I think the network might be acting up again. Mrs. Rotimi, if you could hear us, I was asking whether the death benefits of an annuitant, right, whether that death benefits can be extended to others by virtue of the letter of administration. Hello? So it seems Mrs. Rotimi is unable to.
Yes.
Okay.
Ngozi,
yes.
Please, the network is bad. In fact, I had to relocate to another office, but it's still bad. But can you repeat the question, please? Oh,
okay. The question is basically whether death benefits that are due to policyholders, whether they can be included in the letter of administration. So basically, can a letter of administration extend to the benefits of the policyholder?
Death benefits?
Yes.
No. Death benefits cannot be included in letters of administration. No.
Okay. And the reason will be obvious anyway, because some specific beneficiaries would have been named in the policy.
Yes, certainly. The beneficiaries will have been named in it.
Okay, we may have lost Mrs. Rotimi again, but this has been a very instructive session.
Especially, for instance, in Lagos State now, assuming a person is a civil state, in the record of so, and it is certainly that would be accorded any recognition at all. And of course, I mean, there's no point putting it in the will.
Okay.
Yes.
Thank you so much, Mrs. Rotimi. Does anyone have any closing statements, something that they want to share in closing? Our time is really far gone. It's now 12:39, and we need to be winding down. So I'll just give 1 minute each for each of the panelists to basically give a closing statement or make a contribution that they want the viewers and everyone who's been listening to bear in mind as we come to the end of this webinar. Let me start with you, Your Lordship.
Yes, my advice is anybody above 18 should ensure to make a will. It gives you peace of mind. I don't know what happens when somebody is in the grave, but while you are alive and you know you chose the right executors to administer your estates, it will give you peace of mind that all this estate will not go to extended family who are not in a position to know how you acquire your wealth. You are in the position to know who and who you want to give it to. You might even have charity that you want to bequeath some of your estate to. It is always advisable to write a will. That is my take.
Thank you so much, Your Lordship. Ms. Bogo, anything you want to share with us?
Yeah, we would, as trustees, we always recommend that you seek professional assistance if you seek to set up a trust or write your will. It is always important that you note that your little knowledge about all of these things might actually work against you at the end of the day. So you need someone who is well equipped in this type of business. So I would also advise that you follow ALM Trustees on our social media handles, where we speak more on estate planning and financial planning. If you have children that you want to set up an education trust for, you can reach out to us. If you want to do your living trust or write a will, you can also reach out to us. So if you also have further questions, you can send them down through Ngozi, and she'll directly send them to us and we'll respond.
Thank you so much, Vivian. Mrs. Rotimi, any passing words that you want to share with us?
Yes, please. Like my lady had said, I would say that I would advise people to actually put their house in order. From my experience,
Sorry, Mrs. Rotimi, your
That's
microphone
just,
is-
you know, they just die without making a will. And, you know, you see that myth that if you make a will, you're going to die. I think we have to start sensitizing people that, look, the fact that you are going to make a will is not going to kill you. You see, you have to put that can't even go to school now because, and then there are so many cases of that is affecting the children, it's affecting their education. And then you see, it even puts it puts war and wage in between families. You see, when you see siblings of same parents, same mother, same father, fighting has been a will in the first time. They won't be fighting because the will have expressly mentioned who gets what. And then finally, my last note is that there are so many people out there that they are so confused, they don't even know where to go to when they're in this in such a case, especially people that cannot even afford a lawyer. They can come to the office of the Administrator General Public Trustee, where we will at least for assist them in managing their estates and pending the time that they can actually go to court to get an
we apologize.
If I may chip in.
to get letters of administration to actually come in matter go so people can actually come in and at least they know that they are in good hands. Thank you.
Thank you very much. Your Lordship, you wanted to say something?
Yes, and it is always very cheap. It is cheaper to get probate than letter of administration. It is always cheaper because a lot of people maybe they believe that you have to do a lot of things when it comes to getting a will. Get your will, they read the will, even though they have some things that they will do at the probate registry, but it is easier than letter of administration. So my advice is make a will before you die while you are still insane, while you are competent to do it. It is advisable to make a will.
Thank you. Ugonna, please, do you have any last words for the viewers?
Yes, the previous speakers have covered, you know, the entire field. It's very clear from what everyone has said as to why we need to make a will. I'll just add that, you know, while we may have prepared, we've had the will prepared somewhere, we should also be cautious to watch out for, you know, events that subsequently affect the validity of that will. So if it's the fact that we prepared the will before we got married, you know, we should bear in mind that subsequent marriage can actually revoke the will itself. It may then be necessary to seek professional help to see how you can edit that situation. If you've prepared a will and you've kept it in a safe, you've kept it with a friend or the lawyer that prepared the will, and there is no clear indication as to when the will was prepared, or the fact that, you know, the dates may actually be called into question. From what we've learned in the course of this session, is also necessary to take steps to maybe have the will lodged at the probate registry, such that, you know, when, you know, you move on and there's a need to retrieve that will, you know, litigation that would arise from a challenge to the date of the will, you know, would have been done. We should watch out for these things. I appreciate that there are many lawyers on the call, but I'm also sure that there are people who are not, you know, in the legal field. So you may need to reach out to professionals so that they can help you take care of your loved ones when you're no longer here.
Yeah, thank you. Thank you very much, Ugonna. So let me just say a very big thank you to every single one of our panelists. Thank you, Your Lordship, for sparing us the time this morning to basically go through this very topical issue. Thank you so much, Mrs. Rotimi, for sparing us the time as well. Vivian, we are so grateful for your contribution. Ugonna, we know that you have many briefs, many things that need your attention right now. Thank you so much. It's really been a privilege having all of you sharing these thoughts. And we're also very grateful to everyone who has attended the webinar. I can see that so many of you have stuck with us for almost 2 hours now, and I've just basically listened to all of the conversations that have gone on regarding estate planning. Like all of the speakers have said, without overflogging the issue, estate planning is very important at this point. If you haven't considered it before, now is the time to consider it. But it's not just a matter of considering planning your estate, and it's not just a matter of wanting to do it. It's also a matter of doing it right, of doing it properly, to ensure that whatever it says that you set out to achieve, that you achieve it. So make sure that you have a lawyer to guide you. Do you need to establish a trust? Do you need to write a will? Should you be considering different means or methods of devolving your property? You want to contact a lawyer. You want to contact someone who is really versed in the process of whatever it is that you want to do. Like Vivian has said, if you're going to be needing corporate trusteeship, then you want to be contacting the appropriate person to do that. Yeah, so that's a very important takeaway from this webinar today, is the fact that at this juncture, everyone who is of legal age, and there's quite a lot of very, very useful points that have been made, and we're going to circulate the presentations from some of the panelists after. We're going to circulate that after this webinar. Feel free to contact us. I'm Ngozi Efobi. I'm a partner at හැ. One of my colleagues, Ugonna, is also a senior associate at හැ here. Feel free to contact us. Feel free to reach out to any of the panelists if you have any further questions or something that that you want to discuss. Thank you to everyone who has joined us today. Unfortunately, we've gotten a few other questions that we may not be able to take right now. But like I said, talk to us, send us an email. We're going to put our emails in the Q&A session so that you can send an email, talk to us directly, and we'll be able to answer any other additional questions that you have. Thank you to everyone. Thank you, all participants. Thank you very much, panelists. It has been a lot of preparation gone into this. Thank you very much. We're so grateful. Having said that, we're going to be bringing the webinar to an end at this point, and we're so grateful. Thank you to the partners at හැ who have assisted and facilitated this and made it possible. Thank you very much. We're very grateful to all of you. We're very grateful to all our participants. Thank you.
You're welcome.
Thank you.
Thank you.
Please stay safe.
Thank you.
Yes, that's also very important. Please stay safe. Please stay safe. We want you to write a will, but we don't want you to die yet.
Yeah,
So,
thank you.
please stay safe.
Bye.
Bye. Bye, Alashe. Bye.
Bye.